Welcome back to the Legal Roundtable debate here on the Oscar Pistorius trial, a carte blanche channel. And now, our legal experts for the night. I have Attorney Tyron Maseko, former Zimbabwean High Court Judge, Chris Greenland, and Defence Attorney Ulrich Roux. Your first time, gentlemen, on the panel. Since the break. Thank you very much for your time. We have had quite compelling evidence today. I found it very interesting, but I think my first question, I'll start with you, Tyron. Where's it going? What was the defence trying to achieve with this testimony of Professor Wayne Dermans?
So the way that I see it is that, if you consider the fact that Oscar Pistorius is charged with murder, premeditated murder, but we know that a competent verdict on that is culpable homicide. So the defence is...
Let's just explain the competent verdict. Okay. So if he is acquitted on the charge of murder...
Correct.
The judge then considers a charge of culpable homicide. It doesn't have to be specified on the charge sheet. It's called a competent verdict.
Correct.
Okay.
Correct. And so, because the defense is wary of this fact, that then means that while they're presenting evidence on this murder charge, they also have to be cognizant of the fact that even if Oscar Pistorius is not found guilty on murder necessarily, the court could still apply the principles for negligence to find him guilty on culpable homicide.
Okay.
And so they then have to present evidence which, if you like, sort of ameliorates that risk, that negates that possibility of a conviction.
So they need to get that on the record.
Correct. And if you think about culpable homicide as simply being negligence, failing to live up to a standard of a reasonable man, then you'd understand why they're presenting this evidence, which really goes to, well, Oscar Pistorius, you apprehended danger, as you put it. We don't accept that that is the case, but that's your version. Let's work with that. You thought that your life was in danger and that of your girlfriend, and you had a choice of how you were going to react in that situation. You could have taken the part of least resistance. You could have actually avoided killing someone else by fleeing, quite frankly. You chose not to. You approached the danger. Why? And that is why they're dealing with this aspect of, well, flight or
okay, so they're bolstering a case for the objective test, and we'll go into what that means, and the reasonable man, and now possibly the test of the reasonable disabled man. Ulrich, where do you see this evidence going? Why are they injecting this evidence?
I agree with Tyron, David, and I think we need to go back to Oscar's plea and his plea explanation when the trial started.
Yes.
And that was that he knew what he was doing at all times when he fired the gun, but that he made a mistake.
Right.
Now, when you make a mistake, it says that you were negligent. Now, as Tyron pointed out, the reasonable person test needs to be applied, the bonus pater familias. And that says that a level of adequate and consistent care is required of a person when acting, and when that reasonable person test is applied. Now, I think that the defense is leaning towards the reasonable disabled person test. Now, it is not a...
We don't have that in our law.
We don't have it in our law, but I firmly believe that this is the sort of direction that Oscar's counsel is pushing this witness in order to argue at the end of the day and say that, well, listen here, since the outset of this matter, and since evidence has been led in this matter, we've always said that Oscar has been influenced his entire life by his disability. He's always been this person who has been susceptible to ridicule and to people teasing him, and he would be in danger if confronted with a dangerous situation or a violent situation. And because of that, and this whole flight or fight scenario, that is exactly the reason why he acted the way he did. That because of his disability, he would rather fight and go towards something than rather fleeing. And, at the end of the day, the judge is going to decide whether she accepts that or not. One also needs to consider, of course, is did he apply the principles that was expected of him when acting in self-defense to determine who was behind that door before he shot the 4 shots.
And that's a subjective test.
It is, exactly. And the reasonable person test there does not come into the equation at all.
They might be bolstering the argument for the objective test, should it go to the competent verdict of culpable homicide. But, Chris, are they not injecting this evidence because on the subjective test it is important for the judge to consider those aspects that are so different to other people that influenced Oscar Pistorius? So when she decides this on the subjective test, she's looking at Oscar Pistorius as Oscar Pistorius, the disabled man.
True, and I do support what my colleagues have said, but true, because if Oscar is to be absolved completely, as Tyrone has said that the probabilities verdict of culpable homicide, then the court will have to discard the test of reasonableness, because at the heart of the facts is his advancement towards the perceived danger, towards the door, at which stage, as a reasonable person, he could see that there was no danger. He could see that he was not under imminent threat of injury or death. And then he goes forward and shoots through a closed door. All that is unreasonable. So I agree with my colleagues that if he is to be acquitted, absolved of everything, then the court's going to have to abandon the test of reasonableness, which is at the heart of our law. But to answer your question, I think as regards the charge of murder, what I've just said also applies.
Yes.
I think the defense are on an uphill problem here, because for that very, very reason, in order to absolve Oscar, the court will have to accept that it was not unreasonable for him as a disabled person not to perceive the obvious,
yes,
not to see that there was nothing in front of him, not to see that he was not under imminent threat of injury or death. And I think that that is a tall order.
But also on the issue of Oscar's version of events, if the state wants to show that that version is not reasonably possibly true, the defense is trying to show that those actions that appear not to be reasonable are in fact in Oscar's case reasonably possibly true. That seems to be critical evidence to go to that.
David, you'd be then setting a standard for disabled people which is simply not reasonable.
Yes.
That's what you'll be saying. You'll be saying that disabled people are just not reasonable. You can expect...
Or a different level of reasonableness, Chris?
Well, it's not reasonable that you cannot appreciate what your eyes are telling you. It's simply not reasonable. So...
Not reasonable to be more startled than another person, that you have a heightened sense of anxiety than other people.
No,
isn't that reasonable?
Whether it's self-defense or whether it's putative self-defense, you have to be under threat of imminent injury or death. When it's self-defense, it's actual. Yeah. When it's putative, it's imagined.
Yes.
Okay. So for Oscar to be cleared, then the court would have to set a standard saying, but this doesn't apply to disabled people. They are not required to be reasonable.
I think many disabled people actually took exception to today's testimony.
I saw that on Twitter, yes.
Because he stereotyped completely Wayne Durman. He said that, well, all disabled people are more susceptible to ridicule and to be more in a more vulnerable situation when faced with danger or violence. And I think people took exception to that because, as Judge Greenland says correctly, you cannot just apply this across the board to everyone. It applies to every single set of facts, this test, and to every single person. And did he act reasonable in that scenario, as was expected of him as a reasonable person?
So should we then not, if a case of culpable homicide is to be judged here, in fact, I'm going to get, let me pose the question, I'm going to get you to answer it after the break. If we are going to then say there is the test now of the reasonable disabled man, which we don't have in our law, my question to you when we come back from the break is, should we have such a test? We raise the standard. If it's a heart surgeon who's committed culpable homicide, he's judged according to the reasonable heart surgeon. Do we do it the other way and say there is such a thing as the reasonable disabled man? So I'll ask you that after the break. You can join us on Twitter, on Facebook, on Instagram, and WeChat. Search for Oscar Trial 199. A little later in the show, we'll be looking at your tweets. We're back after the break.